Ladies and gentlemen, I would like to welcome you to today's presentation, Non-Discrimination in Healthcare, Section 1557, What You Need to Know, part of the Medical Mutual Insurance Company webinar series for 2016. At this point, I would like to turn the presentation over to your host, Lauren Hooser.
Thank you, Jessica. As Jessica mentioned, my name is Lauren Hooser, and I work in the Risk Management Department here at Medical Mutual. Our department is responsible for bringing you the annual webinar series. Today I have the pleasure of introducing Susan Friedenberg and Allison Laban as our guest speakers. Both speakers work in the Greensboro, North Carolina office of Smith Moore Leatherwood, LLP. Susan is a partner at Smith Moore Leatherwood. She has over 20 years' experience representing clients in the healthcare industry with a focus on long-term care providers and hospitals. Susan has assisted healthcare providers who want to offer a new service through the Certificate of Need process and helped existing providers maintain their licensure and certification. Additionally, she regularly counsels clients on corporate and regulatory compliance, HIPAA and data security privacy, and fraud and abuse. She graduated from the University of Kansas with highest distinction and Wake Forest University School of Law. She has been listed in Best Lawyers in America Healthcare Law annually since 2013. Our second presenter today is Allison Laban. Allison is a partner in the Healthcare Practice Group. Allison works with hospitals and other healthcare providers to identify, respond to, and resolve compliance issues and keep their businesses running. She focuses her practice on state and federal regulatory compliance and fraud and abuse issues, including HIPAA, privacy, and security requirements, False Claims Act violations, Medicare and Medicaid billing and coding, facility licensure, response to OCR and OIG investigations and inquiries, and day-to-day operational compliance and risk management activities. Allison graduated summa cum laude with a bachelor's degree in history and Spanish from Wofford College. She graduated with honors from Duke University School of Law. And now I'd like to turn the presentation over to our guest speakers.
Thank you, Lauren. Thank you all for joining us on this very important topic. We've been receiving a lot of questions from our clients. We know many of you have questions, so we're pleased to join you today. So starting right off the bat, what is Section 1557? Section 1557 is a component of the Affordable Care Act that has broadened and expanded the definition of discrimination in healthcare. And specifically, it requires that an individual shall not, on the grounds of race, color, national origin, sex, age, or disability, be excluded from participation in, be denied the benefits of, or be subjected to discrimination under any health program or activity that receives federal financial assistance. So as a provider, if you accept Medicare, Medicaid, CHIP, TRICARE, or any other federal health care program, you are subject to 1557. There are two primary components that providers need to be concerned with under Section 1557, and this is how we have split up our presentation today. The first component deals with the provision of language assistance services to limited English proficiency patients, what you need to know to provide them with the appropriate documentation and the appropriate language assistance services to be in compliance with the federal law. The second component of the final rule dealt primarily with recognition of patients' expressed gender identity and how you should appropriately interact with and serve patients who are transgendered or otherwise have a non-traditional expressed gender identity. There is a good bit of information that you have to collect and submit to be able to show that you're compliant with this provision of the law. You have to submit an assurance of compliance form that details how you were in compliance with Section 1557. There are also a number of requirements about the information you actually have to post and make available to patients that we're going to discuss in some detail. It includes a non-discrimination notice and certain what the government is calling taglines, which are little bite-sized bits of information that direct patients where they need to go for further assistance. They recommend the development and implementation of what's called a language access plan, i.e. how you will make language services available to your non-English speaking patients. And then if your practice employs more than 15 individuals, a requirement that you designate a compliance coordinator and adopt grievance procedures that address grievances arising out of the provision of language assistance services or the provision of services to patients with non-traditional gender identity. That gives you a little flavor for the broad scope and reach of this particular requirement. I'm now going to turn it over to Susan, who's going to address in particular language assistance services for limited English proficiency patients.
And I'm going to start by talking about posting requirements that have just come into effect October 16th, 2016. They were mentioned, referenced in the final rule of May 18th, 2016, but were not required to take place till October 16th, 2016. So if you have not yet done the posting, you're not that far behind, and hopefully you can get it done here quickly after listening to the webinar. To begin, I wanted to address what needs to be posted. There are two things that need to be posted, and we'll discuss where they need to be posted shortly. One is the Notice of Non-Discrimination, which has been expanded based on the requirements of Section 1557. And then you will need to post 15 taglines in the top 15 languages spoken by limited English proficient patients in your state. So the non-English languages need to be posted. Let's start with the Notice of Non-Discrimination. The good news is that there is a lot of information on the Office of Civil Rights website that helps you with these provisions. There's an actual sample Notice of Non-Discrimination that can be found at the www.hhs.gov Civil Rights site. So we would direct you to that link that's included in the presentation so you can see the Notice of Non-Discrimination. You do not have to use that particular Notice of Non-Discrimination, but if you create your own, you need to ensure that it includes the following provisions. First, you do need the actual language that states that you as a provider do not discriminate on the basis of race, color, national origin, sex, age, or disability. And you need to track that language specifically. Second, you need to inform your patients that you provide appropriate auxiliary aids and services. Next, that you provide language assistance services, and the Notice of Non-Discrimination on OCR gives them some example of sign languages and type of aids that you can provide. So you have to have the notice that you provide those types of services, and then you need to explain to the patient how to obtain these aids and services. You can't just say that you will provide them, but you have to give them some guidance on how they can get them. You have to identify and have contact information for an employee who will coordinate efforts to comply with Section 1557. So you need to have a contact information for your patients if they have questions about the aids or language assistance services, and also if they have questions or are requesting investigation of grievances or complaints. You need to note that there is a grievance procedure available. So obviously for all these things, you will need to have a grievance procedure already in place when you have this Notice of Non-Discrimination. You'll need to have your aids available so that you not just have a notice that when people call and ask for things, they're not available. You need to demonstrate how to file a grievance and also how to file a discrimination complaint with the Office of Civil Rights. Again, the information regarding how to file that complaint can be found on the OCR website, and you can just cut and paste as needed for that language. Now, covered entities can combine this notice of non-discrimination with notices required under other federal civil rights laws, such as Title IX and Section 504, so discrimination for employees, that type of thing. I would not necessarily recommend that because, as we'll discuss later, we have the notices of non-discrimination not only in English, but in any other language that you might need to convert. And if you go in and start adding additional information, you won't have that easy translation available to you. But if for some reason you want to just do one large notice of non-discrimination, that is permissible. You just need to ensure that you have clearly informed the individuals of their civil rights under Section 1557, so that it includes those 8 components that we just went over. Taglines, as Allison mentioned, that is the name that has been given this short bit of information with regards to providing language assistance services. And you need to have posted the top 15 non-English languages in your state. You need to have a translation that says something as simple as, attention, if you speak Spanish, language assistance services free of charge are available to you, and then call and give the number. And so you'll do that for 15 non-English languages. Again, OCR has provided and translated 64 taglines that does cover all the 15 languages in North Carolina, and I think covers it pretty much across all the states. We've listed here the top 15 languages in North Carolina. I'm not going to go through every single one, but the top 2 are Spanish and Chinese, and then Vietnamese is following that. So that information, again, is available on at CMS Appendix A and in the OCR website, so you can look in case it changes. Again, the commentary has stated you don't have to rely on the OCR information. If for some reason you have another document you want to rely on in identifying the top 15 languages, as long as you can demonstrate to OCR that that was reasonable, they will accept that. But like I said, they've already got those 64 non-English languages translations done for you, so I would, again, recommend just following their lead there, because you know you won't be in trouble for not identifying the correct language. All right, so now let's talk about what does it mean to post the notice of non-discrimination and the 15 taglines. Throughout the regulation, they talk about that it has to be conspicuous and visible. So there's a specific regulation that states that you have to use conspicuously visible font size. So it can't be so that you can jam it all on one piece of paper. You can't use teeny tiny font. It has to be something that folks can see and read easily. You will need to post in physical locations where the provider interacts with the public, in a conspicuous location on your website, accessible from the website's homepage, and in significant publications and communications. So those 3 places, where you interact with the public, on your website homepage, and in significant publications and communications. So let's talk about how do they decide where you should post when you're interacting with the public. Again, they're considering if it's sufficiently conspicuous and visible to individuals who are seeking your services or participating in the health program or activity. They have to be reasonably be expected to see and be able to read the information. So sort of a common sense, you can bring your nurses in, somebody be a pretend patient, and think about, well, where am I going to be that I would like to see this notice of non-discrimination and know what language assistance services are available to me. Possible examples are waiting rooms, check-in desk, posted on the front door as people come in. So again, part of it depends on how your facility is structured or where you're interacting with the public, and it'll be a case-by-case basis potentially on where those postings need to be made. Some questions have arisen about whether handing the notice of non-discrimination and taglines to a patient is sufficient. And while that certainly satisfies the intent of the legislation, which is to make sure that everyone is aware of their rights and the availability of language assistance services, unfortunately, the regulation did not have an exception along those lines and specifically states that the notice and taglines must be posted. And so since it must be posted, we would recommend that you can provide a copy of the notice, and that might be a great practice, but you also need to post the notice in the common area as well as the 15 taglines. Posting of notices in languages other than English is encouraged but not required. We would recommend that you look at your patient base. If you have 50% of your population that speaks Chinese or Spanish, then it probably would be good to have that notice of non-discrimination in that alternative language posted next to the English one. But again, it's not required, and it really is, again, on a case-by-case basis, looking at the population you serve and what's going to help them and then also you avoid questions and concerns. So moving on to the second place where the notice and taglines need to be posted, and that's significant publications and communications. While significant is not officially defined, they have stated that it will be interpreted broadly. So if you're looking at a publication and communication and you're wondering whether it would qualify as significant, you should err in favor of yes, it is a significant publication and communication. Looking at different examples that have been given, they include patient handbooks, outreach publications, educational materials, marketing materials, and then this is where you can start assessing and analyzing your documents. They've indicated they include written notices pertaining to rights or benefits, written documents requiring a response from an individual, for example, billing documents that would require a payment of a check. So those are some examples and would help you figure out if what you're looking at is considered a significant publication. And then informed consent is one document that has been identified as an area where an interpreter is necessary. And so from that standpoint, it should definitely contain that notice of non-discrimination and the 15 taglines identifying the availability of the interpreter. And we'll talk a little bit in a minute. You probably only need 2 taglines on your informed consent document. The informed consent must offer appropriate interpretation services. So you can't force a patient to rely on bilingual family members or friends to interpret the documents. Now, some folks might have a whole bunch of marketing material or patient handbooks that have already been printed and are sitting in their office. Do you have to throw those away and start over or try to slip sheet in a notice and taglines? No, you do not. You can continue to use your existing stock of publications. Once you run out, you need to include the notice and taglines on any new copies. I would recommend that anything printed after October 16th should have that notice and taglines included, and you probably will want to have potentially some documentation of when you had that last printing in case they come in. You know, I mean, it's potentially a year from now. You might still have that document depending on how many you made and what you're giving out with marketing material or patient handbooks. So you'll want to have some documentation to prove that this isn't a new run that you just didn't include the notice and tagline on, that these are left over from before October 16th, 2016. Now, as I mentioned with informed consent, you might only need to have 2 taglines, and that's because there is an exception for postcard, trifold brochure type material or small pamphlets. Obviously, that notice of non-discrimination, when I read through all the 8 sections that have to be included, is going to be a long document. It's going to take up a page. The 15 taglines, even though each one is short, when you have 15 of them, that's probably going to take up another page at least. So if you just have a small publication, obviously you wouldn't have room to put any of your material. So they recognized that and indicated for these smaller publications, you can have a limited notice in English. And that limited notice simply has to say that you will comply with applicable federal civil rights laws and do not discriminate on the basis of race, color, national origin, age, disability, or sex. So you just have to have that language, and again, it's on the OCR website, is that specific language, so you can use that and know that it is an acceptable limited notice because you got it from the website. And then on those smaller publications, you only have to have taglines in the top 2 non-English languages. So in North Carolina, that would be Spanish and Chinese, that you would have to have the attention. If you speak Spanish, language assistance services are available to you. With regard to the website, again, you have to have the complete notice of non-discrimination and 15 non-English taglines. Both the taglines and the notice must be accessible from the home web page. Now, you don't have to have the notice of non-discrimination in its entirety on your website homepage, and you don't have to have all 15 non-English taglines. You can simply have a link to the notice and a link to the tagline. For the link to the notice, it would be similar to what you probably have on your website now with regards to notice of privacy practice. People click on that at the bottom of your homepage, and they go to your notice of privacy practice. Here you would have notice of non-discrimination highlighted. They click on notice of non-discrimination, and it takes them to the full notice document. With regards to the taglines, they have stated specifically that you can just have the one word in a particular language to go to the tagline. So, for example, an easy example is you'd have Espanol. Click on that, and it would take you to the tagline that says if you speak Espanol, and we've got it there in Spanish, and I should probably have Allison read it since she has a Spanish degree, but it would take you to that tagline. You can't write out Spanish, though. If you have Spanish written down as your link, that's not acceptable. They want to see Espanol. So for Chinese, you're going to have the Chinese characters. You're not going to have the word Chinese as a click, because they want folks to be able to recognize their language and be able to click on that link. And just a point of clarification there, obviously, your taglines must also be in the foreign language that matches your link. So you would have I'm going to let Allison say it in Spanish.
Si habla español, tiene a su disposición servicios gratuitos de asistencia lingüística.
That was much better than if I had said it. You're not going to write on your tagline, if you speak Spanish, free language assistance services are available. So you need to make sure to use that native in language provision. The language access plan is not required, but in considering whether you are meeting the requirements of Section 1557 to provide this language assistance services, it is recommended, and it will help protect you when folks come in if there's grievances or complaints about that you do not have these services available or you do not have a plan in place. If you have drafted a language assistance access plan, that will be helpful. It's considered an essential tool to ensure adequate and timely provision of language assistance services, which is one of the meanings of the Section 1557, one of the purposes. The plan does not need to be long, complex, or burdensome. They specifically said they're looking for something short and just to the point. And again, you're going to have different plans depending on your circumstances and who you're serving as far as what is going to be sufficient. If you do get in trouble and there's a question about whether you are satisfying the requirements, then you might be required to have a language access plan as part of an enforcement action. But at this point, it's just good to have because it will help you stay in compliance and will be considered when evaluating your compliance. Some appropriate components of a language access plan that have been identified include how you determine what primary language is being used by your patient. So when that person initially comes in, how do you determine if they speak Spanish, if they speak Chinese or Vietnamese? Also, how did you identify and what is your telephonic and video interpretation service that you have available to these patients? The identification of a qualified translation service is along that same lines and could be provided by the same interpretive service. Then types of language assistance that may be needed in given circumstances, depending on if it's an emergency coming in or just a regular appointment, again, dependent on the services you're providing. And then also you want to identify documents for which translation should be routinely available. So for example, the informed consent document would be one that you would want to make sure that you have available as necessary for individuals that speak different languages. The notice of non-discrimination might be another example of a document to have ready to go, or at least you know that you can turn to somebody and they can get that to you quickly. So those are just some components of a language access plan. You know, the main purpose of it and what you want to focus on is how am I going to provide services to individuals that come and see me and need health care and do not speak English proficiently. So using that as your starting point, come up with a plan to do that. I'm now going to turn it back over to Allison to talk about the second major provision in Section 1557.
Thanks, Susan. Sex-based discrimination is defined in the regulations as any discrimination based on the sex of an individual, the individual's status as someone who is pregnant, who has just gone through childbirth, or who is experiencing childbirth-related complications. It is also defined as discrimination based on a person's expressed gender identity, as well as sex stereotyping. This is a broad definition. It is certainly broader than what we have seen in the past. And in developing this broad definition, the regulations note that there has yet to be a court case that definitively links discrimination on the basis of sex with discrimination against a transgendered person or another person with an alternative gender identity. However, the regulations make it clear that that is the policy across the various federal agencies. They report a number of court cases that, while they have not gone so far as to make that link, have certainly laid the groundwork and are clear that in the eyes of the federal government, discrimination on the basis of gender identity does qualify as sex-based discrimination. So this will come as a change to some folks, but we want to make sure that you're aware of the view that the feds take of this particular issue. The regulations make it clear that gender identity is fluid and is going to depend on your individual patient. So they go on to define it as an individual's internal sense of gender, which may be male, female, neither, or a combination of male and female, and which may be different from an individual's sex assigned at birth. Because gender identity is defined in terms of the individual patient, that means you have to talk to your individual patient and cannot make assumptions based on physical presentation or the sex assigned at birth when you're dealing with these patients. Moreover, healthcare providers are required to treat individuals consistent with their gender identity. There are certain limitations on that, of course. The regulations make it clear that you are not required to offer a prostate exam to someone who does not have a prostate, or a hysterectomy to someone who does not have a uterus. However, in other situations where appropriate, you need to be prepared to treat the patient in accordance with his or her expressed gender identity. Just failing the first time you meet a patient to use what they identify as the appropriate pronoun is not enough to push you into discriminatory territory. However, it does rise to the level of discrimination according to the regulations when one's failure to acknowledge and respect the patient's gender identity is sufficiently serious to interfere with or limit the individual's ability to participate in or benefit from healthcare services. So examples of that include overt hostility that is persistent and intentional. So having met the patient states that he identifies as a man, you continue calling the patient Cheryl and using the pronouns she and her despite the patient's expressed preference and expressed identification of gender identity. A refusal to correct the patient's name and pronouns in the medical record. This is a little bit of a gray area. In most cases, I think it's going to make sense to, especially if this is a long-term patient that you've been treating who undergoes a gender transition, to link medical records so you have the historical information about the patient, and then new records going forward rely on the patient's expressed gender identity. And then a refusal to provide needed medical services. So for example, if you have a patient who was born male who now identifies as female, but that patient did not go through gender correction surgery and still has male genitalia, if you refuse to provide treatment that she may need for prostate cancer or the examinations that she might need for prostate cancer, that would be considered hostility rising to the level of discrimination. So there are some very practical steps that healthcare providers can take to avoid giving rise to a situation in which you are accused of being hostile towards a patient based on his or her expressed gender identity. They include revising registration forms. So for example, if you have a registration form, you hand that little clipboard to every new patient who walks in, and on the line of sex you have male, an M in a line, an F in a line. Consider doing away with the M and F and just write gender and leave a line and let the patient tell you how he or she identifies. We suggest providing some type of private space to ask follow-up questions if necessary. So for example, if a patient who was born male now identifies female, you're registering the patient, it would be appropriate to take them to a private office and let them know we do not discriminate on the basis of gender identity. However, to be able to provide you appropriate health care, we may need to ask some questions about care you received under your sex assigned at birth so that you can explore, for example, if a trans man still has his uterus, you need to know that so you can know how to best treat the patient in certain situations. So it's appropriate to ask those questions, but it needs to be done in a thoughtful, respectful manner, and certainly not while the patient is standing at the registration desk surrounded by a room full of strangers. Training staff, of course, is always key in these situations. Staff need to know how to respectfully obtain the necessary information from patients and how to basically follow the golden rule in kindergarten about being kind to others and being respectful to others, and know the type of information they need to gather and the type of information they don't when dealing with an individual with an expressed gender identity that may not match what they're seeing in front of them. We also suggest that you implement billing or coding safeguards, or make sure if you're using a third-party billing company that they implement these type of safeguards and use appropriate modifiers. This can raise an issue, again, if you have a patient who has undergone transition later in life. And so if you don't appropriately code and use the appropriate modifiers for a claim, let me give you an example. Patient who was born female now identifies as male. If you provide a certain health care that typically only males receive, your billing and coding systems can kick it back out because they're looking for patterns. So if every bit of treatment up until March of 2016 was female-oriented, and then suddenly starting in June 2016, after the patient transitions, it's male-oriented, that can cause claims to kick out. It can cause some billing confusion. So you just need to make sure that your billing and coding folks are on the same page and they know how to deal with these particular situations. And then if you're using an electronic health record, you need to make sure that it allows you to change the patient's name if necessary, to change the patient's gender if necessary, and if not, make sure that it allows you to create a new record that is linked to the old one so that you still have that patient's medical history, their family history, things of that nature, but that going forward you are using the appropriate gender identity as expressed by the patient. That's a really easy area where things can get tripped up. You certainly don't want a situation where something as simple as the patient requesting a copy of his records triggers a discrimination suit. So, enforcement, where the rubber really hits the road. OCR, as Susan mentioned, the Office for Civil Rights, has two primary purposes. On one hand, it enforces HIPAA compliance. On the other, it enforces anti-discrimination compliance. They have for many, many, many years been enforcing and investigating allegations regarding failure to provide appropriate language access services to patients. Traditionally, we have seen this arise primarily in the context of deaf individuals. Their allegations hit on both discrimination on the basis of disability and, if they speak American Sign Language, on the basis of limited English proficiency, because ASL is not English, and so providers can really get tripped up in those situations. We see fewer enforcement actions involving individuals who speak a language other than English orally. That is probably because traditionally these individuals did not have the resources available to them or the knowledge about making an allegation or filing a grievance. As Susan noted before, the Notice of Non-Discrimination and other documentation you are now required to provide requires you to let patients know they have a right to file the grievance, either with you or with the OCR. So we do anticipate seeing these type of investigations picking up in the future, although we will note that the OCR has traditionally been underfunded at best, and most of their compliance energies these days have been focused on HIPAA. But again, it's always a possibility. OCR oversees compliance in the areas of the Americans with Disabilities Act, Title IX, which deals with sex discrimination, the Rehabilitation Act, which was Section 504 mentioned earlier, and the AGE Act. So any broad range of discriminatory actions in healthcare are going to fall under the enforcement purview of the OCR. They have, in fact, brought enforcement actions against physicians in the past. Here's just one example. The Mid-Maryland Musculoskeletal Institute, which is an 11-physician ortho practice up in Maryland, a complaint was filed alleging that this very large practice that served thousands of patients a year failed to provide interpreters for deaf patients. The OCR sent a letter, which is always the first step to let you know that you're under an investigation, and noted that if Mid-Maryland did not cooperate, they were facing a loss of their participation agreements in federal health care programs, which of course is devastating to most providers. The way these investigations work is you get the letter with the allegations, and typically attached to that letter is a long laundry list of documents and information that they would like to see. As Susan noted earlier, while the language access plan is not required, it's basically required because they're going to want to see it. And frankly, it's the easiest way that you can show that you are doing what you are supposed to be doing, because you have it all there in one nice, neat document that you can submit to OCR. But they're going to ask questions, and they're going to want to see your policies and procedures. They're going to want to see evidence of training provided to your staff, as well as sign-in sheets and other information showing that not only do you support training, you've actually provided the training. They're going to want to see any contracts you may have in place with third-party language assistance programs, including, in this particular case, sign language interpretation. They're going to want to know if you have a history of receiving grievances from patients who require language assistance programs. And they're going to want to know what population you serve. So as Susan noted earlier, if 50% of your patient population is made up of Spanish speakers, but you do not provide any language assistance programs, that's going to get you in a lot of trouble. Contrast that with a provider who serves no foreign language speakers. While they still have to comply with the law, the impact of their failure to comply is much lower than the practice that serves 50% Spanish speakers but does not offer translation and interpretation services. So Mid-Maryland played ball, as we always encourage you to do, sent off their documents, admitted they had a problem, so they entered into what's called a resolution agreement with the government. That's the government's fancy term for a settlement agreement. And under that resolution agreement, they required that they would provide language assistance programs. They were required to draft new policies and procedures, submit those to the government for approval, and then implement them once approved by the government. And they were required to train their staff in accordance with the training plan that the OCR laid out for them. So certainly it is always better to do this on your own time, in your own way. It is always going to cost you more money if you reach the point where you have to enter into a resolution agreement with the government. We have successfully defended several healthcare providers who were alleged to have not provided appropriate language assistance services. In every case, it helped that they had a language access plan in place. They had appropriate contracts with third-party language assistance providers. In each of those cases, it really was a failure of communication among frontline staff, for example, registration staff, who either did not know or did not remember how to appropriately obtain language assistance services for the patient. So as Susan noted earlier, the threshold is whether the services are both adequate and timely. So the sooner you can make these services available to patients, the better. It obviously does not do a lot of good if you register a patient, you bring them in, you provide them the service, and then you hand them a sheet of paper that says, oh, by the way, if you need language assistance programs, here's the number to call. So even if you have an appropriate program, if you're not timely offering those services to patients, that can get you into trouble. So the gold standard that OCR and other federal investigators apply is that of meaningful access. And meaningful access is not defined anywhere. It's in some ways similar to the Supreme Court justice who many, many years ago said, well, I don't know how to define pornography, but I know it when I see it. And that's basically the approach that the feds take. They're going to know it when they see it if you are ensuring effective communications with your patients or not. So, of course, it's easy in the case of limited English proficient patients. Are you providing appropriate language assistance programs that are both adequate and timely? With the gender identity patients, it's a little bit more nebulous, but it's going to come down to whether you have processes and procedures in place so that you're respecting and reflecting the patient's gender identification and treating that patient. So certainly it all comes down to whether the patient can communicate his or her needs to you, and you can communicate to the patient the risks and benefits of the procedures that you're offering. So certainly there is not effective communication if the patient does not receive adequate information. As Susan noted earlier, you cannot require patients to have a family member translate. In some instances, they may request that, and you should honor the patient's request after letting them know that there are other better options available. Simultaneous interpretation is a very difficult skill, and certainly in the medical context, you need someone who is appropriately trained not only in the language, but who understands and can express medical terms, because in many cases, common medical terms in English, there's no direct one-to-one translation. So the person providing the language assistance has to truly understand the medical terms so that he or she can appropriately interpret and explain to the patient. There is not effective communication if the patient doesn't understand the services and options available, does not have the ability to express his or her needs and concerns, and because of these language or other discriminatory barriers, cannot receive the services and benefits for which she is eligible. So when you think about it that way, how can I best communicate with these patients? It can help you suss out the practical implications of this and how, knowing your patient population and the services you provide in your individual practice, what can we put in place so that we're best communicating with our patients. The feds agree that there is no one-size-fits-all plan to achieve meaningful access. So, for example, a multi-hospital system with thousands of employees is going to be held to a much, much higher standard than a single physician practice with a few hundred patients. That does not mean that the single physician practice does not have to comply. It just means that compliance is going to look a little different. And the factors that are important include the size of the population that you're serving that has these needs, the sizes and resources of the individual provider, the nature of the program or services you provide. So, for example, a provider that offers a critical service is going to be held to a slightly higher standard than a provider who does not. So, for example, if you solely provide cosmetic surgery procedures, you are likely going to be held to a slightly lower standard than a provider who offers oncology care, primary care, emergency services. They're going to take that into account. And then, of course, the frequency with which limited English proficient individuals come into contact with the provider, or in the case of gender identity, the frequency with which transgendered and other similar patients come into contact with you. So if you find yourself the target of an investigation, the investigators are going to focus on the end result. So they're going to look at what you have in place, but the end result is, are you effectively communicating with your patients such that they can receive necessary services? So you have some flexibility in here, and it would really behoove you to sit down, look at your patient population, assess your resources, and come up with a good, effective plan to how you can best serve those patients and, frankly, protect yourself. Because if there is a communication barrier and a poorly trained or untrained interpreter, the patient may be telling you, for example, there was a case a couple years ago where an individual from Haiti came to a hospital in the U.S. They speak French Creole in Haiti, which is not the same thing as French. So the hospital pulls in a resident who said, yeah, I had some French in college. Well, the resident mixed up. The patient was complaining of chest pain. She interpreted it as abdominal pain. They did an abdominal scan. You're fine. Sends him home. He dies of a heart attack. So not only is it best for the patient, it is best for you as the provider that you know what your patient's complaining of, that they can appropriately communicate to you what hurts, what their symptoms are, what their issues are. You certainly do not want to be practicing medicine in the dark with one hand tied behind your back, and unfortunately that's what happens if you don't have appropriate interpretation services available. So at the end of the day, OCR boils it down to 4 keys to compliance. Are you assessing the needs of the population to be served? Have you developed and implemented appropriate policies so that your staff knows how the system works and can make sure that these resources are available? Are you training your staff so they can understand and carry out those policies? And are you monitoring on a regular basis Is our system working? Are we happy with this third-party interpretation service with whom we've contracted? Are we seeing patients who speak a foreign language come to the practice and then they disappear, they don't come back? Is that a sign that we're not meeting their needs? So they expect you to do a little self-reflection every now and then to make sure that you are meeting all the requirements. So in terms of what you should be doing next, we strongly encourage you to visit the OCR's website. It is very rare that the government is this helpful, but in this situation, as Susan noticed, they've done the translation for you for the notice of non-discrimination, for the taglines. There is no need to hire a translator for this particular project. Go get them from the OCR. Then look at your policies and procedures. Do you have a grievance policy already in place? Do you have a policy or a language assistance plan that lays out how you're going to provide language assistance services to patients? Do you have a policy that addresses how you're going to interact with patients with a non-traditional gender identity? Have you looked at how you're going to obtain these interpretation and translation services? We can certainly make recommendations. There are a lot of great companies out there. If you Google telephonic language assistance, you're going to get a laundry list of providers. You want to make sure that they are providing certified interpreters. There are rigorous certification exams that interpreters have to go through to become certified. That ensures that they are trained in simultaneous interpretation. And those interpreters should list languages and ideally dialects. So, for example, many Asian languages have very specific dialects. The same can be true of Spanish. Many words are not the same in Spain. It's the exact same word, but the meaning is quite different in Spain than it is in South America. So you want to make sure that you've got robust services available. There may be opportunities if you are a small practice to look at some group purchasing options with other small practices whereby you can negotiate a group contract to receive these type of telephonic interpretation services. There are certainly right ways and wrong ways to do that. We would encourage you to consult with your legal counsel to make sure you're doing it correctly. But there are some options to help you deal with the cost. As we mentioned earlier, you want to look at your policies and procedures. You want to evaluate your forms and your processes to make sure that you're capturing information appropriately from patients so you can reflect their needs both from a language standpoint and from a gender identity standpoint. And then write it all down. Create that language access plan. It will make your life so much easier should someone file a grievance against you with OCR. If you have all that information at your fingertips, you can copy it, sit it in a binder, and send it off to them. So we're sure many of you have questions. This is a lot of information and a lot of change to process. We would certainly encourage you to reach out to us or to your existing legal counsel with questions. As we noticed, the OCR has set up an entire website dealing strictly with Section 1557 compliance, and as well as other federal agencies, CMS in general, others have provided information on this topic. We thank you for joining us today. Have a great day.
I would like to thank our speakers, Susan Friedenberg and Allison Laban, as well as Jessica, our event producer. The Risk Management Department at Medical Mutual hopes that you've enjoyed this presentation.